Hey, right, everyone, evening. Just let me get myself sorted. So, usual blurb. If this is your first YouTube live stream, just basically the rule is, or one of the rules is, don't ask questions about your own situation in the first person. So you obviously ask questions about your own situation, but just put it in the third person as a what if question. What if someone was in had been served a Section 21 notice and the councillor told them to wait till the bailiff comes, you'll get exactly the same answer as if you put it in the first person, but you don't have to share your personal data everywhere. And it also helps you think through. It helps, I think, isolate the kind of the issue that kind of people actually dealing with from a legal point of view. Bear with me a sec. I've just got to do this. Yeah, no, I've done it all. Yeah, cool. Okay, so yeah, let me just pin that message. So that's the first thing. Second thing is that this is not it's not legal advice. So we're also going to do our best here to be helpful, but we can't understand everyone's complex kind of situation and stuff, all the information. So we're going to try and give some pretty generic stuff a lot of the time. And also, there's only one question this week that's coming through the week, so this could be a very short live stream, basically. If you want to ask a question, don't hang about because we might be finishing in like 5 minutes because the question that's coming is very easy. Before we get into it, though, what I will do is just talk very briefly about something I'm working on, which is kind of right. Let me explain why I did this. The local government and social care ombudsman has all their decisions on their website, except that they don't have all their decisions on the website because they seem to remove them after a certain amount of time. And also, it's proper rubbish to use their search function. You search a keyword and you just come up with all sorts of tripe. So I've basically started the process of working through just interesting decisions, and I'm going to put this somewhere at some point. Maybe I'll see if we'll put it up on his website. But it's basically like the code which you can use to search on the thing on the website, which council it was, and then kind of keywords. So this one's about who can advocate for people as an example. There's like a summary of what was said. So I'm just kind of working through them methodically, really. But I've found some interesting ones already. I've found several about bailiffs, and kind of been told to wait till the bailiff comes again. This one here is interesting because this is a question that me and Will have batted around a couple of times about mental capacity when making a homeless application. And although there have been some LGSO decisions which you kind of touched on it, this actually kind of really deals with it very thoroughly. And in this case, the council basically or the housing team had basically incorrectly concluded the person didn't have mental capacity to make a homeless application, so refused the application in the in the teeth of the evidence from their colleagues in social services and the psychiatrist. So yeah, it might seem a bit of an obscure issue, but often the LGSEO is the best source of information for this sort of stuff. So again, you kind of repeat sort of things. Advice to wait past the Section 21 expiry, protection of property, prosecution of landlords. There's some interesting stuff in there. But as I say, so I'm just kind of working through it. At some point, I'll put it up there. One of the reasons I'm doing it as well is that a few weeks ago now, someone on the live stream asked about suitability of B&B accommodation for single people. Now, obviously, we talk a lot about there being a 6-week limit on on B&B accommodation for families with children or pregnant women, but single people obviously don't come under that. But clearly, if you're single and you're living in a B&B, then there's going to be just exactly the same kinds of issues you're going to have around paying for food, cooking, that sort of stuff. So I'm looking for something around this. Basically, I've not found anything yet, but I haven't forgotten that question. I think it's a really good question that came in, as I say, like I think 3 or 4 weeks ago. So I'm going to get there basically, but I'll make this available when I kind of get a few more cases on there. Just kind of doing a bit at a time. But anyway, that's me. That's my news. Anyone else want to share anything, any gossip or anything like that this week?
It's only a small thing, and just reiterating what I'm watching, but not a benefits live stream Q&A tool. But I did find out this week that as long as your UC is at least £1, whilst you're in supported housing, your full housing benefit will be paid. Which sort of blew my mind because we often talk about how you can't work in supported accommodation because the rent is so expensive. But actually, as long as you've got £1, like at least, do you know what I mean? Your UC claim is open, and you're in the limited capability for work-related activity, then you'll get full whack of housing benefit, which I think just opens up the ability for a lot of people in supported accommodation to part-time work if they want. Which again, by the way, I'm not saying your worth is at all relevant to your employment status, but a lot of people keeping busy and doing something is actually really beneficial for various reasons. So yeah, thought that was cool.
That's very cool. Yeah, thanks, Shannon. Nice bit of gossip. Anyone else? We've got some people behind there. There's how you right, John? We've got John Martin and Michael this week. You all right, guys? Hope you're all right. And we have got a question coming actually. So yeah. Right, yeah. Should we get onto it? Will, you got something? So
Yeah,
I'm
I
only one
just say
screen tonight, guys. So I'm going to be like just floating. Sorry, I'm going to be getting this wrong. But yeah, sorry, we'll go for it.
I haven't read it in detail yet, but the Housing Law Practitioners Association has now released their letter of complaint, I think it is, to the one of the social housing monitoring bodies about the London Borough of Lambeth and how they are providing a sort of consistently dreadful service across many areas of housing. I'll try and look at it and report back on it. The thing that's going across my mind is that Lambeth's an easy target to sort of kick because they've always sort of been up there as sort of criticised for being useless and just bad. But I just find I mean, so many local authorities are just dreadful at the moment that it seems a bit unfair to pick on Lambeth. But I did speak to somebody from Holper about this, and they said, no, believe me, they are really much, much worse. So more on that, and if I can come back later, I'm planning to have a rant about mental health support for people in homeless situations.
We'll
But
see if it comes
I'll
up.
pause on that till we.
Yeah, cool.
Yeah.
Yeah, I mean, it might be it comes up naturally. So I know that Doughty Street Chambers a little while ago we're doing like a call for evidence about against Lambeth because they were. I mean, I don't know what. Yeah, how can you be worse than Waltham Forest or like these other councils? You know, it's difficult to be, but I don't know. It sounds like they're doing it in some way. And also, there's a case for those who are watching who haven't subscribed to Nearly Legal. So nearlylegal.co.uk is a blog done by a solicitor called Giles Peaker, and he does like kind of like significant case reports and summaries and stuff. He did one this week about a Haringey Law Centre, I think, and I don't know if it actually involved Haringey or who's culpable for it, but effectively it involved ChatGPT or a solicitor using ChatGPT. It seems, again, I don't want to kind of say that definitely happened because that wasn't the finding, but it seems that some sort of AI was writing the kind of documents for court and made up some cases. They basically made up some case names. They won anyway because it was pretty obvious it was the council was wrong. But just we've talked before about ChatGPT and how good it can be, but clearly it does seem to have a propensity to make up case names. So I did that video a little while ago about kind of like trialing, kind of getting it to do certain tasks, and it did a really good job. Things like writing a complaint. Once you kind of tell it what to complain about, it did a good job of writing the complaint. But it seems it's still quite a way away from being able to be a reliable, kind of alternative to actual legal advice. So yeah, just to put that warning out there, really. So right, no, in fact, we're going to go straight to the live stream because the chat because the question that came in through the week wasn't anonymized. So well done live stream for being anonymous so far as I can see. First question I can see is this one. It's a multi-part, so just bear with me a minute. Let's also just share the right screen so you guys can see what the hell I'm doing. So here we go. So yeah, question one, this is the first part. Let me just get the rest of it. As I say, I've got one screen tonight, guys. I'm away from home, so don't have my usual setup. Right, is it just two parts or is there more? Hold on, let me just scroll down a little bit. Oh no, there seems to be more. Hold on. Okay, I think, oh no, there's a bit more. Okay. So, I think that's all of it. So what if someone had been allocated a final offer of housing and waited for 4 months, but that house was occupied and the tenant went to court and it was decided they cannot be evicted, and you found this out by contacting a councillor, and now you've been given a new allocation. It's been 3 weeks on the state, which is currently a session has been on the news for the crime. Am I misreading that? Has been the news for the crime, and you're a young woman fleeing domestic abuse, needing to work with anxiety, so feeling worries and unsafe. You've not been asked to view the property, but have the postcode can elaborate a question, but type on a tablet, so not easiest. Okay, so right, first of all, just say that's not a completely unusual situation where a housing association is expecting someone to be evicted, and so it's kind of saying, yep, yeah, you're going to be good, you're lined up for this property, and then there is some kind of issue with the eviction, as in they mess it up some way. I've seen it before where they basically completely missed someone's disability and then had to kind of, they lost the case when it went to the eviction, or whatever. So you've now got, I mean, essentially the question here is they've now got a new offer of accommodation which is on an estate, which is obviously got some ASB issues by the sound of it. And the individual's worried. So okay, and I guess the question would be, is there a can you turn down that property? Now, I'll explain it from a couple of different points of view, just to kind of, we'll try and get to the actual answer. But if you're a council and you have I mean, I would imagine most districts, most towns, most cities have areas which are, kind of highest crime rates. There will be kind of hotspots or whatever. If you're a council, they cannot admit. Well, in my experience, they won't admit that there's a problem, because as soon as they say, "Oh yeah, do you know what, this estate over here or this road over here is terrible," then what they're going to do? They're going to have rehouse everyone on that street? Then they're just not going to do it. So I guess that's just kind of making a point that, in my experience at least, councils will be very, very reluctant to kind of entertain that argument on its own. So I think that's kind of the starting point here, is that you're up against it to try and show that there's a good reason to refuse an offer. So I guess, and it doesn't sound like there's any kind of specific risk. So let's say, for example, you have someone who's fleeing domestic abuse, and the council try to house you somewhere which is kind of in close proximity to the perpetrator or the perpetrator's family or friends or something like that, so that actually there's a plausible risk you're going to end up bumping into the perpetrator again. That would be a sound argument, I'd say. I've kind of seen that happen quite a few times. That would be kind of a strong position you're in. But if you just don't, if it's just the reputation of the area, the fact there's been crime there or whatever, on its own, I've never seen that kind of. I've never. Let me put it this way. I've never seen that argument being made successfully. So I think realistically, the question is going to be articulating what kind of support or what kind of help you think you might need. I'm trying to think, like, whether there's any you can kind of draw in from, anything you can draw from that kind of might kind of increase your case. Certainly, if you've got high levels of anxiety, the council should entertain the kind of situation. They should listen to what you've got to say. And there is something in the code of guidance which says that you should be given the opportunity to see accommodation before you'll move into it. However, I think that there is a little caveat to that. Let me just bring up the code of guidance, actually. I just brought up the wrong guidance. Hold on. No, not damp and mold right now. Let's try and do that again. And I'm also just trying to remember what the wording is I need to search for here. Let's just search for the word viewed, see if I find it. Right, this is going to take a couple of moments, guys, so bear with me. It's not working at the moment. It's all awesome. Right, no, there's 277 hits for that, so that's not going to work. View the property. Let's just search for that term. No matches. Okay, so right, I'm going to keep trying to find. Let me just bring up the code of guidance so you can see what I'm looking at. But I don't know that I'm going to find this right now. Whilst I'm trying to find it, does anyone else want to kind of come in on this question and see if you've got anything else to say about it, just in case there is some good news somewhere?
Well, I could say that I agree with you. I've never heard of somebody being able to turn something down without viewing it, or on the basis that it's in an area which is high crime or something. But one thought I was just having while we were talking about it was, if somebody has a specific personal condition, such as they're victim of a survivor of abuse, or they've got PTSD, and they can get medical evidence supporting that, arguably you could say that even if they happen to see a newspaper article saying this area is particularly violent and so forth, you could say they'd suffered a reaction to that article, which meant that they couldn't consider an offer. It's not one I'd feel comfortable running, but it might get you around that problem, like you said, Mike, that if they say, okay, such and such an area is so awful, we can't offer anybody accommodation in it, they've cut off the ability to, I mean, they're never going to do that because it's a sort of policy thing. But if you could show that it was just specific to you, then I think you might have a bit of a chance, rather than just saying, oh, it's a bad area, I don't want to live there. Because I used to try that in Clapham Junction. There used to be an estate, well, it's still there, called the Winstanley Estate, and it has actually been sort of yuppified and done up over the last 20 years. But back in the 90s, it was actually, if anyone remembers So Solid Crew, it was where they sort of used to hang out, and there's a video somewhere of them pointing out the spots where they used to deal drugs and stuff there. And a lot of people would refuse that area and say, I'm not living on the Winstanley estate. And they couldn't get away with doing that because they'd have to say, well, there's no evidence that you'd be at risk there. And so it was difficult.
Yeah, it's easy for me to say this, but technically I used to live on like the murder capital of England for a short space, statistically speaking, and I had no issues there at all. But again, that's just easy for me to say in the circumstances. So I guess I don't. It doesn't sound very much prospect of kind of making the argument successfully. I mean, this is the bit I was just talking about actually. So, but as I say, it's kind of weaker than you'd hope. So applicants should be given the opportunity to view accommodation before being required to decide whether to accept or refuse it, and before being required to sign any written agreement relating to the accommodation. If the accommodation is in another area or it's not practical to travel to view, sufficient information about property and locality should be made available to them. So, I mean, I'd say if it's in your kind of close proximity, as in like it's in your in your district or something, you can travel to it. Then this would, that first kind of part of this paragraph would say, no, you should be given an opportunity to go and view it. But I don't know that that's going to help you. I don't know that that's the kind of the kind of really what we're getting at here. So, yeah, oh, yeah, sorry, go on.
I just want to check something. Sorry, because I know you download the code of guidance, and I was just looking at the online one. 15.46.
Bear with me.
Just to see if it's the same or changed. Because 15.46 talks about the Secretary of State saying that they need to view it, but then 15.48 also sort of talks about a reasonable period of time, depending on the area and sort of maybe seeking advice. So potentially, and this is a push, right? But if you've got domestic abuse service in the area, actually a meeting with them to sort of go, right, this is the area, there's lots of ASB. Do you think it's going to be suitable for me as, an ex-survivor of domestic abuse? What sort of, because they'll have an understanding potentially of like perpetrators in the area. So it's sort of honing in on the specific type of antisocial behavior potentially that you might be vulnerable or not vulnerable to, and you're bringing in a professional opinion. And that might just give you enough like that reasonable period to sort of consider the offer of accommodation.
I think, yeah, I think I think the problem you got with domestic abuse, because domestic abuse is where you're going to be at risk from a particular individual or group of individuals, and so kind of unknown individuals who might kind of be problematic for other reasons. I don't think it's going to. I don't think you can draw that conclusion, but I think you're right in terms of you can kind of insist here that you have they can't just rush you into making a decision, and I guess a good housing officer will be looking to listen to that person's views, and consider them carefully, hear them, and reassure the person basically, and really, realize it's a very understandable kind of position to be in. My guess is, my fear is, a lot of housing officers were just trying to, basically say, oh yeah, well, if you don't take it, we're going to end duty, and that's going to be it. So, I think you really got to be careful. Going back to what we kind of regularly say is that turning down an offer of accommodation, like, is a real kind of a massive risk, basically, because it doesn't necessarily end all duties to you, but it's going to end any good duties to you, really. So unfortunately, I think on that point, I think realistically, unless there's kind of specific kind of issues around the kind of the risks that you'd be at, I think yeah, ask for more time, ask to view it, voice your concerns to the council, try and explain to them why you're kind of in that position. But I don't think you would be sensible at all to refuse the offer. So that's I think that's what we're saying really there. So sadly, that's not particularly positive, but I guess it's what the situation probably is. So cool. So next question. Okay, Struth, got a lot in the live chat. Right, hold on, guys. So. Oh yeah, so just some kind of think bouncing off what you were saying, Shannon, about the sport accommodation and earning money and stuff. So right, I think this is the next question I can see. Am I sharing the screen right now? I can't see. Right, question. So and this one, there's more parts to this. I think. So question, person request a review under section 202. The deadline for the council, 8 weeks plus 2 weeks extension on the 6th of May. Not heard any received a decision. How is that person's situation looking at the moment? Is it possible the council will reply in the next few days, or by them not replying, does it mean a negative decision? So I would say the fact that they have or haven't replied, I don't know really has much of a bearing on whether or not it's positive. In fact, I'd probably say, if anything, if they think they can basically not overturn the decision, as in they kind of uphold the original decision, I think they're probably more likely to do that earlier rather than later. But that's kind of, you know, we're not talking a significant margin there. I think they're more likely to probably drag their heels if it is actually a positive decision, as in they're going to have to, you know, overturn it. So my experience as a non-lawyer, I would complain about this and basically say, you know, hurry up. But I guess as we always kind of say, you're in this kind of like really impossible situation to know. You're always at risk of like annoying the council. So I think probably, you know, start with just politely chasing it. And then if you really don't get anywhere and you think you've got a strong case, then maybe chase it a bit more assertively. So, but yeah, I think, because yeah, I've certainly had cases where, yeah, I basically kicked up quite a bit of fuss and got it sorted out. But and kind of, yeah, just kind of refused to agree to the extension and stuff, and I just kind of complained that they'd taken way too long. I think in one case they'd taken 10 months, so I was probably right about that. But I think the solicitors here, so Will and Karis, might say something different in terms of just always agreeing to extensions or whatever. But yeah, I think but yeah, in terms of what, I don't know, that's my answer. I don't know if anyone else would kind of answer that differently, guys.
I wouldn't say I wouldn't say differently, but I would say just reiterate that by email that the extension's gone up. Do they require a further extension? Because she's got limited time to, if she needs to appeal to the appellate court, so she needs to keep an eye on making that decision.
Cool. Yeah, and so yeah, I mean, I guess without knowing the detail of the kind of the review and stuff, it's probably worth approaching a solicitor if you can, which is easy again for us to say. It's difficult in reality, because ultimately, if you do get knocked back at that review decision stage and you haven't got a solicitor lined up, you're going to be struggling to kind of get things, you know, kind of sorted out in that time. So yeah, there's that kind of to bear in mind as well.
But I just add a tiny bit to that the 8 week deadline as extended, once that's expired, the applicant can make an sorry. That's it. Sorry, the applicant can appeal to the county court after 21 days. So they've got that runs from the date when the council completed the review or should have completed the review, yeah? So if you get to the stage where this person is at, where the extension, the deadline's expired, I mean, I would do what Karis said, is write to them and say, look, the deadline's expired, you need more time. If we don't hear from you, we're going to appeal on the basis that you've failed to carry out a review. Now, then you can appeal it, and then if they don't come back to you, then you can ask a judge to make the decision. The other thing is if you miss the 21 days, so let's say if this person leaves it until the 28th of May, and that'll be more than 21 days from the date of the deadline expiring, you could go for a judicial review and you could ask for an order requiring the council to carry out the review, so you're not completely stuck. Or you could ask for the High Court to deal with the review, which the County Court would have dealt with by way of an appeal, on the basis that you can't do the appeal now.
So just to understand, because the person's put there. So the way I read that sentence is that essentially the 8 weeks expired like on the 24th of April or something. Then they had this additional 2 weeks. So is that 21 days run from the end of the 8 week period that the review should be done in, or the extension? Sorry, I missed
the extension. That bit. If you agree an extension, then that's fine. Okay. So it's 21 days from then. What can't happen is nobody can agree an extension of the 21 days once that's expired, because that's up to the court. But you could then go back and say, well, because it's 50, the 8 weeks can be extended. So okay. Basically, you either appeal and say we're asking for an appeal on the basis that they haven't done a review, or you judicially review them later on the basis that they haven't done a review and they can't do a review and they can't do an appeal now. Hope that makes sense.
Yeah, well, I think what you're saying there, Will, is that you need a solicitor because that's confused the hell out of me. And then that leads me to the next $1 million question: is how is Virgo's capacity right now? Because I know you've been swamped recently. I don't know if you guys have got, if someone was to approach you through the
Well,
online form.
I think we're sort of okay to take stuff on. So I'm still sort of I'm not turning people away at the moment. So
Okay.
that should be okay. Is that fine okay with you, Karis? I mean, we can share them between us if you're getting too many.
No, yeah, we're good.
So I'll dig out the link and put it in the live chat, although I don't think it actually fits. So guys who are watching the YouTube, if you go onto the YouTube channel section, like the live section, like last week's recording, and I'll do it for this week's as well when it comes out, becomes recording. The first like bit in the text is the link to Virgo's, and I'm guessing, I mean, how do people kind of access that directly? Is that on your website or something, Will? The actual link to the, you're on mute.
Muted myself. The link is to a Google form, and then they fill that in, and it gets processed from there.
But what I'm saying is, where can they get the link from? Because I've
Oh,
got
I'm
it.
sorry.
Yeah, I've
I
got it.
think the link is on. They can get it from my blog.
Yeah.
Let me just double check. I think there's a section called resources. I don't know this off the top of my head. So W.
So your WFLAG, is it WFLAG Law? I never remember which
If you just
website,
type
which is your channel.
wflag.com or wflag blog, you'll get there. And then
Cool.
there's a section called resources, and then there's a section called solicitors carrying out legal aid work. Maybe that's just the list.
I'll dig out in a minute. I'll put it into the live
Yeah,
chat so we'll find it.
I'll make it more easy.
Yeah.
I thought I'd put the link on there. I did I did a blog post about, but of course it's not the most. Yeah, links for people looking for help with solicitors. That's the one. So I'll send you if I put that.
So if you put it in the Zoom chat, I'll put it into the live
I'll
chat.
put it in there now. Hang on.
Nice one, thanks, Will. Right, whilst Will's doing that, let's get the next one up, which is this one here. So if an individual at risk of domestic abuse and has mental health issues is accepted under the main duty, could the council end their duty owed to them and take them out of interim temporary accommodation for any reason? So once you owe the main housing duty, so that's what it sounds like we're talking about here. So you're then going to be in temporary accommodation whilst you're waiting for a final offer, whether it be through the housing registry or whether it be a private rented offer of accommodation. The only way you can, I mean, I know we're being really pedantic here, so I apologise, but I guess it's the law, so it is pedantic. So at that point in time, it's no longer temporary, it's no longer interim accommodation, it's temporary. So interim accommodation is what you get between making an application and then reaching the decision that you're owed the main duty, and then you're in what we call temporary accommodation. I appreciate it's all kind of like, colloquial terms that we confuse sometimes. But so if you're in temporary accommodation under Section 193, which I think is what this person's saying, the only way you could get evicted is if you were to, kind of, well, usual kind of break the rules of the temporary accommodation, that sort of thing. There's an interesting fact, whilst we're talking about LGSCO cases, there's an interesting one I saw, actually, I've not read properly, but I just kind of share this one because it's kind of relevant. And it talks about, where is it? So essentially someone was, here we go. So, oh, this one, hold on, Will, you're on, yeah, cool. So Liverpool City Council, if you Google this number here, I'll put it into the live chat just so you can kind of, oh, bollocks. Hold on, I should delete everything. Here we go. So, yeah, if you put that code into the LGO website, I've just put it there. Basically that LGSCO case involves a situation where they basically evicted this guy from what I think it was interim accommodation, but the same rules would apply for temporary probably. And effectively, but they failed to actually kind of fairly do it. They didn't actually ask him what happened. So where is it? Yeah. So failed to investigate if his eviction was justified, blah, blah, blah. So that was kind of something which resulted in failure. So essentially, councils can't just like arbitrarily evict you. They'd have to kind of go through a fair process to figure out what it is they think you've done. They need to kind of probably get your side of events, you get your version of events, if that's what we're talking about, before they can start actually evicting you. So yeah, in terms of other situations, unless you refuse an offer, yeah, they make an offer, they think it's suitable, you refuse it, they could end the temporary accommodation duty then. But yeah, I don't know. That's I say that's kind of I'm kind of reading into that question a little bit there. I don't know if there's other ways of reading it, but that would be my answer. Anyone else want to add to that at all? Bear with me a sec, just checking there's no more to it. Okay. Right, so there's another question as well which follows on from that sort of. But yeah, let me just kind of do that as well. So I think we've answered question 3. Question 4, and again, I'm just going to go back to that LGO document again, because there was another good one somewhere about paying for TA. And again, it was kind of like, it was basically where they were working and the council kind of failed to do it. But by looking at the LGSCO decision, you can kind of get a lot of stuff. Here we go. So this one here, Dudley Metropolitan Council. Again, I'll put the code into the live chat. So again, you can kind of Google that in the LG. If you just go to lgo.org.uk, you'll get the thing, you just search for it. But essentially, again, within that decision, there's a lot of stuff around, kind of, yeah, how much he was supposed to pay, all that kind of stuff. I'm sure there's another one in here as well, actually. But these, yeah, so these are the kind of things I'm trying to gather at the moment, to kind of put together. But yeah, I'm sure there was another one as well somewhere. I can't see it now. But yeah, but basically, okay, let's just go back to the actual question. Just actually make sure we answer it. So in terms of you can work in temporary accommodation or interim accommodation. You will be eligible for some help from the council, but you'll also be, you'll have to pay a certain amount yourself. And so the council should give you very clear advice about how much that is. So you essentially need to declare your earnings to the council, the housing benefit department, the housing officer, whoever, and they need to kind of, they'll basically say how much you need to pay, but it won't be the full whack because some temporary accommodation is extortionate. You won't be able to kind of afford it yourself. So the council, it's the kind of principle underpinning it is that any accommodation the council give you has to be suitable. That must include an assessment of affordability. And so the council need to kind of work out how much you can earn, how much you earn, how much you can afford, how much the actual rent is, and they kind of need to make up the difference in effect. That's kind of how it would work. So yeah, that's hopefully, again, that's an answer to that question, which I think kind of covers it. But again, guys, just chip in if you want to add anything to that.
I guess just on the bills side of things, like when you're in interim accommodation, like electricity, everything else is covered by yourself. So unless, like, for whatever reason your situation was extremely unaffordable or the bills were extremely high, normal sort of everyday bills, in terms of maybe Wi-Fi, electricity, water, that sort of stuff, you'd be expected to cover. Yeah.
Cool. Thanks, Shannon. Anything else on that
Sorry.
one? Oh, you're going,
Yeah.
Karis.
I'd just say sometimes when they talk about rent and being covered by a housing benefit, sometimes you've got to pay a little on top of the housing benefit that you receive. So check on that, and service charges sometimes aren't covered by the housing benefit.
Yeah.
So always try and keep a record of, and sometimes they'll say, oh, you don't need to pay this bit. So the council aren't always correct in what they're saying. And sometimes you'll get arrears, and housing benefit is paid in arrears. So you'll accrue some while it's being paid off. So the council will be like, oh, you're in arrears on this bit. So you just got to keep a record and not rely on the council information that you're giving. So keep your own records. That's long.
Yeah, cool. Yeah, I think is whenever you've got a question like that, always put it in writing to the council to make sure you can show you mastered it. The actual one I've just taught, this is one I was actually thinking about. So this is Slough Borough Council, and again, just to read the summary, Miss X said the council did not deal with the housing properly. The council did not inform Miss X of her rent properly or complete affordability assessments. This, I think, was for temporary accommodation. She suffered accrued rent arrears, financial loss, and avoidable distress. The council should pay £300 for the avoidable distress, repay her £2,700 payments, reduce the rent account balance to zero, and provide guidance to staff. So, again, read that kind of LGSCO case, because again, it kind of gives a lot of good kind of detail about how council should work. Cool. So next question. Again, some multi-part, so just bear with me. Question 5. Nearly there. Right, then finally, I think this is the final one. Cool. So, at the end of November 2024, a family with children was accepted under the relief duty. The council refused to accept that it owed the main housing duty. So ordinarily that could be because of three things. One would be because the family is not, then they're saying they're not homeless, or they're saying they're not eligible, or they're saying they're intentionally homeless. Because a family with children, assuming they're dependent children under the age of 18, they will be in priority need. More concerningly, the council went on to close the homeless application entirely. A review of the decision was requested following the closure. Whilst this was ongoing, the landlord initiated a possession order review. In response, the council reopened the case, but only under prevention duty. Given that the family is not intentionally homeless, can they file a complaint with the LGO for the council's failure to provide main housing duty? So no, good question, but no, there might be some stuff for the LGO to do here. So, Shannon, have you got to?
I was just going to say, do you want to share the questions?
Oh yeah, yeah. I can see it. Well, what's wrong? Hold on. Yeah, that's a good idea. So here we go.
Sorry, I don't want to interrupt the flow, but
No, that's all good. No. You need to interrupt with that. So yeah, and let me just whilst I'm thinking about it, let me just put that link into the chat that I promised. So this is a link to the form that will hopefully open up the possibility of getting into Virgos. So cool. Right, and now you're seeing my chat for some reason. Let me just unshare that a minute. It's a disaster, isn't it? Yeah, cool. So yeah, here's the question. I'll just start again here. So yeah, so family were accepted under relief duty. Now, the relief duty should only be accepted when the council is satisfied that you are in fact homeless and you are in fact eligible. But I guess it is still open for the council to make a not homeless decision if, for example, they found out something else afterwards, maybe. So yeah. So I guess what we probably need to know is why the council refused to accept the main housing duty. More concerning, the council went on to close homeless application entirely. So that would suggest to me they're saying it's not a homeless decision. That would be the way it would normally work, or not eligible potentially. A review of the decision was requested following the closure, and I'm assuming at this point this person's still living in the private rented accommodation. Is that right? So yeah, you still got landlord. Well, assuming private landlord here. Possession order is kind of the eviction is kind of proceeding. So, okay, prevention duty is owed to people where the council is satisfied they are in fact eligible and they are in fact threatened with homelessness, which means they are likely to become homeless within the next 56 days, which would ordinarily be the duty that you get when you are given a valid Section 21 notice and it's within 56 days of expiring. Now, bearing in mind, Section 21s can last for like 58 or 60, or I guess 62 days if it was July and August or something like that. So that you can't necessarily make a homeless application immediately and be under prevention duty, but it should happen pretty quick. So that's again, that's some facts which will hopefully unpick this a little bit, but I'm not sure. I probably need to know a little bit more. Yeah, I mean, I'm just trying to think. Maybe yeah, going to the complaining about this and going to the LGO is not your kind of probably your first point of call. You probably want to just unpick this because the LGO can't investigate decisions. They can investigate whether the council considered the right things and did the right, offered interim when they should have and stuff, but they can't say whether or not the council's decision was right. That's for the courts. So if you take a complaint to say the council said I wasn't homeless when I was, the LGO would say you should have gone to court. There's nothing we can say about it. So yeah, is there anything more? I'm struggling to kind of say anything more without any more detail about this. I don't know if there's anything else down the line. Oh, hold on, there is a bit more. Sorry. Oh, I'm not sure if that helps us really. So this is an additional comment. Refuse the main housing duty after 56 days of relief duty. Okay, so I don't know. I'm not quite sure. I don't have enough information here to know exactly what's happening. Yeah. I guess what I'd want to know is when they refused the main housing duty, what was the reason they said? Was it because they said you weren't homeless, or was it because they said you weren't eligible? They're saying they're not intentionally homeless. So I'm assuming that's not a factor either. So I don't know what else it might be. I think we need to know what was the reason the council said that the main duty wasn't owed for us to be able to answer it. So yeah, people are nodding, so I'm going to assume that I think we need to, we'll hang on a minute. We'll wait to see if there's that kind of a detail is added in, and then figure out if we can actually answer it more thoroughly. So for the time being, we'll go to question 6, but we can go back to question 5 if we get that more information. And guys, if you see it in the chat before, because I say I can't see anything this week, so just give me a shout. So question 6: what banning on the housing register can an individual usually be placed in, silver A, B, C, if they suffer from mental health or a victim of domestic abuse and in a waiting list for an autism? I guess it means assessment. Have I missed a bit? Yeah. Oh yeah, no, there's more to it actually. Bear with me. Autism, PTSD, ADHD assessment. So, and then this kind of question leads on as well. So we'll put these together. How you right, Shadownet? Nice to have you here, mate. Cool. Wrong button. Hold on. Right. So thanks for bearing with me there. What banning on the housing register can an individual get? Okay. And then what is expected time frame it is likely to take to overturn non-priority decision individual for an individual with various mental health issues. Okay. So we can't give you a straight answer, but we can kind of give you some useful information. Every single council in the country, and there's about 300 or 310 of them or something in England, they all have a different policy when it comes to banding. Now, most of them are vaguely similar. So most of them have, bands A to D or whatever, bands 1 to 4, whatever it might be, gold, silver, bronze. But the only way to answer it is to go on that council's website and search for the term, or in fact, if you just go on Google and say Bedford Borough Council Housing Allocation Scheme, use that term, housing allocation scheme, it should immediately pop up and say, here's the policy. And it might be called something different, but it is their housing allocation scheme. That's the technical term for it. And in that, you're going to have a section which is about banding. And then with the, let's say it was bands A to D, it would kind of say, band A, people who are trying to downsize in social housing, they're under occupying. They'll almost certainly be band A because the council, because they want to free up larger properties. It might be something like at risk of immediate domestic abuse. That's usually in the kind of highest banding. And often, not every time, councils generally will have people owed the main duty in either band 1 or band 2, the highest, one of the 2 highest bands generally. Again, you need to read the detail of policy. And you may also get, so it may be that you're owed the main housing duty and also you get additional points for disabilities, which all of these things could be a disability. Obviously, the person's waiting for the assessment, so he doesn't know yet exactly what's happening. Although I probably would say that you don't have to wait. It's not the diagnosis that really matters in housing law. It's what your kind of your difficulties are. So it may well be that you have a condition and it's not yet diagnosed, but the council should be looking at, okay, what impact does it have on you, rather than to say, oh well, we haven't actually got diagnosis yet. So that's kind of my first answer to it. Is you need to go on a council's website and just check out what the policy says. But that's the kind of things you're going to see. You're going to see this kind of like banding system. Generally, there'll be a lower band for people owed either the prevention duty or the relief duty, and it will generally go up to band, a higher band when you get the main duty accepted. And there'll be other things in there as well. It might be that the council's got a particular kind of policy around, or particularly banning around veterans, for example. That's not unusual. So that's kind of, say first part of the question. And in terms of the expected time frame to overturn a non-priority decision, so I guess it in part is going to in part depend on what medical evidence there is already. And although I've just said it shouldn't matter about the diagnosis, in reality it does. So it would probably be really kind of helpful to get that assessment to come through, particularly for any of those issues really, to get some more detail about it. But it may be the GP has already got some information about it, which would led to them making a referral. That could happen. So there might be some information which is already kind of enough to kind of get you, get there. So once the evidence been gathered, it's not particularly difficult, really. Priority need is one of those things where actually if you have a solicitor and you have some robust information, then it's pretty straightforward. So yeah, that's not really helpful in terms of time frame, but that's probably the best I can give. Does anyone else want to come in on this one just to sort of say about anything else that I've missed?
I don't, but just there is a follow-up question that's also around sort of expected timeframes around, to finish challenging the suitability of temporary accommodation, interim accommodation offered to an individual placed in shared or B&B if they required a self-contained property due to mental health conditions. So I'm assuming it's all linked, but
Yeah,
I didn't
sounds
have
like it
anything to
is.
add to your answer, sorry.
No, it's okay. It's cool. I might just kind of try and give a more succinct answer in a minute because I felt like I just waffled a lot there. But let's just look at this last part as well. So, what is the expected time frame? Is it likely to take to finish challenging suitability of interim accommodation to an individual placed in shared B&B if they require self-contained? Again, having a solicitor is going to be really helpful here at this point, because the answer is a lot of councils, they'll just basically just keep kick it into the long grass really, and just not really kind of take it seriously, just take forever. There's no reason why it can't be done very quickly. It's only going to be a few, really, it's just going to be a case of just gathering some more information and someone making a decision. So it doesn't actually take a lot of man hours to actually make that, kind of do it. But a lot of councils will just get bogged down with the, being over capacity and stuff. So I don't know if I can give a more helpful answer to what I've given, but I don't know if anyone else wants to come in and say anything about this lot.
Can I jump in on that one?
Yeah.
So I think the starting point is, I was thinking when I first read the first bit, is obviously it's going to be the if it's a section 184 notice saying you're not in priority need, the time frame would be, I mean, if you think of the sort of slowest time frame, it would, you've got 21 days to request a review, then they've got 8 weeks to complete the review, and then you can appeal. So somewhere, and the appeal could take months. So somewhere along that time scale is where it would happen. But that's not a very satisfactory answer, or it's not a solution anyway, if the person has the problem. So if you take it a step further and say that, because finding non-priority may be a reason for not giving somebody temporary accommodation at the first stage, and they're really saying we don't have reason to believe you're in priority need, or we're satisfied that you're not. In which case you can challenge that quite quickly, because if you've got, as you say, if you've got some strong evidence, you can then go for a judicial review, and the timescale for that is much shorter, because the risk here is that the person is going to be street homeless because they're either not being offered, and it would be going on to the other part of the question, if they're being offered unsuitable accommodation which they can't occupy, then they may be sleeping in a car or sleeping on the street. So the solution to that is you can get a time frame of days, if not weeks. But what you do is you send the information to the council with a judicial review pre-action letter. You give them as much time as you think they need, which could be hours rather than days. Because if the person's going to be homeless tonight, you say to them, I'm sorry, but we're not going to give you the usual 2 weeks. And then you go for a legal aid certificate and issue the papers in court. So you could, in theory, turn that round in a matter of days. And the court would then, if they're satisfied, order the council to not to overturn the finding of priority need, but to provide accommodation or suitable accommodation if it can be shown that that's needed. And the implication would be they'd have to withdraw the finding that they're in priority need. Does that? I hope that makes sense and doesn't.
Yeah. So it made me think of a couple of examples which might just be helpful to talk about. So, individual's case I was involved with many years ago had suspected Huntington's chorea, which is like serious fatal illness basically. But the test takes months to get because it's like this genetic testing you've got to do, and although there were kind of signs that she had it, essentially eventually the council did correctly apply the test, which is reason to believe that you might be homeless, might be eligible, might be in priority need. So because there was kind of reason to think she might have Huntington's, she had family history of it and so on, which is its genetic disorder, and she was exhibiting signs of kind of behavioural issues and stuff. the council eventually correctly kind of said, okay, well, even though we don't have a diagnosis yet, we have reason to believe that they might be in priority need through this diagnosis. So they effectively kind of housed her and waited months before the test actually came through to make a decision, which probably wasn't necessary, but that's what they did. So I guess it just kind of gives an example of how these different thresholds work and how, again, you don't need to have a diagnosis to get help from a council. So sorry, Will, if I just repeated what you said there, but yeah,
No,
or added to it or whatever. So one of our regulars just kind of said here, which I just kind of referred back to that one of the first questions we looked at. So I managed to argue against a housing placement in an area where there had been homophobic attacks in the area and argued it was unsafe for LGBT people as they were repeated and unsolved. Wasn't easy, but really, yeah, I'd imagine that kind of took a lot of fighting. But kind of going back to that kind of question about domestic abuse and kind of being placed in an area where there's a lot of issues. I mean, again, I guess I'm slightly pessimistic about making that particular argument, but here, if there's, I guess what we can see here in this example is that there is an issue of someone presumably being kind of LGBTQ and there being those homophobic attacks, and obviously those two things go together. Whereas if you've got a domestic abuse survivor, but there's no kind of direct kind of link between that and the risk, then I'd say it's harder to make. But that definitely makes sense. But I think, I think it's, what we said earlier about, I think you need to show why there's a link, a kind of an objective link between the domestic abuse previous experience and a particular individual group of individuals in the area to make that argument. But yeah, I just thought I'd put it on the screen. I'll take it away now because it's not a question, but yeah, it's good to hear that it's been done. So, and I might just miss some stuff. I just realised I might have missed a few bits. So I'm just going to go back and check I haven't. So, you are Richard. You are Stella. Where are we up to? Okay, so just to reiterate, guys, we're not taking questions in the first person. I know it's annoying, but it's just to avoid a number of things. One being putting data, your personal data onto the internet. So if that person could just rephrase their question as a what if question, then we might be able to answer. And I'm very soon gonna just kind of close down questions for the night. So be quick with that because we'll probably kind of start winding things up soon. Just kind of just make sure I'm not missing anything here as well. So yeah, I think I've covered everything there. The one question that came in through the week, which wasn't anonymized, which is why I'm saving it till last, is this one here. For some reason, it's done that. Yeah, so I asked the council what number I was on the list, and they told me that they don't keep numbers. I don't understand how they decide who's next. Then other councils have numbered list of who's been waiting longest. Okay, so interesting question. There are some councils. There's a group of councils down in Essex and potentially Suffolk, which do a really good job of like providing information on their website about kind of waiting times and that sort of stuff and like how long it's going to be. And actually, that's a legal requirement. So basically, the law says that councils should be really transparent about waiting times and kind of how long people should expect to wait. But those group of councils, like Braintree was one of them, I remember, like Colchester was another. They are quite, that they're the kind of the exception rather than the rule. So there will be a list. There is obviously a mathematical way of calculating the way that people wait, but they just won't be publicizing a number. So generally the way it works is you obviously have your bands A to whatever, D, and everyone in band A is effectively competing against each other. And effectively, the person who's been on band A the longest will have the highest priority. And then if no one from band A bids that week on a property, then someone from band B will get priority. But again, it will then be a question of how long have they been in band B before, kind of work out the priority. So it's not that the council doesn't have a list. It's just that they're not kind of telling you what number you are. And in one sense, the number itself is probably not terribly helpful on its own, unless you kind of have some kind of other kind of data around average waiting time. So people who's 10th on the list or something, it's not necessarily particularly helpful. So yeah, so this person is right. There are some councils do have like kind of a lot of information, and also you'll often see when you bid for a property, it'll say you finish 20 out of 500 or something. That again is kind of gives you an indication of how, where you are on the list. But again, if you're talking about people in band B and there's 500 people in band B, if there are people also on band A who are bidding that week, they will trump anyone in band B. That's the way that certainly most policies are. Well, every policy I know, that's how it works. So yeah, I'm going to give a couple more minutes just for that person to, if they want to just reiterate or rephrase their question and make it anonymized. Other than that, is that everything? Did I say we're going to come back and do something at some point? Feel like I said I was going to circle back. Sorry, I've had a very long day. But if we don't think of anything right now, another 30 seconds or so, we'll call it quits for tonight. Yeah, I'm just going back through the live chat to see if I've missed anything else, but I don't think I have.
I was going to have a rant about mental health support,
Yeah,
but
go
leave
for
that
it.
for another day. I think
You
everyone's
sure?
a bit too tired to
Sleep on
listen
it,
to
yeah.
that right now. I'll try and structure it better.
Yeah.
But I was wondering, one question I had, if Martin Ayres is still out there, unless you guys spotted it. There's a comment earlier on saying, yep, bingo, many councils fail to realise this. We have a template list for clients to fill in and send. And unless I missed something, I don't know what that was referring to.
It was about Shannon's point about claiming housing benefit if you work in a support accommodation.
Oh, I see. So sorry, it was about that.
Yeah.
Okay.
So just there a last question that's come in, just it's probably worth answering as well, since we're talking about banning and stuff. So can banning be challenged? Yes, it can. Councils again regularly get it wrong. There will be some kind of internal review process. Legally there has to be a review process in place, but every council again would do it differently. I mean, probably pretty similar in most councils. So they'll kind of say, you need to write to this person, the review officer, to kind of put your case forward. And sometimes sometimes there's nothing kind of sinister in it. They haven't done their, kind of haven't ticked the right boxes or whatever. So it can often be often be very obvious that the council's not put you in the right band. But also there can be times when, let's say, and this is quite a common issue, where you might have domestic abuse mentioned in bands A, B, and C. And in band A, it says, serious threat to life. And then band B, it says, significant risk. But these words are like very, very elastic and very, very ambiguous. So it's very difficult to kind of often actually say, well, I think I'm at serious risk of extraordinary harm, or whatever the wording might be, because it's kind of then just becomes this kind of war of words. So yes, you can challenge it, and sometimes it will be really obvious. I mean, it can be something as simple as like, I don't know, they've missed off the medical needs of a household member, then it's really, obviously that's going to lead them to get medical priority. That could be something which is fairly common. But as I say, there can be sort of much more, kind of like there's kind of just like a sliding scale about issues. And it's then quite difficult to actually kind of say to a council, look, I think, you need to upgrade me because I think I'm slightly further up the scale than you're saying, basically. So, yeah. Cool. Oh, go on, Stella. Yeah. Here we go. Last question. This is the really last question. If someone is threatened with homelessness and council doesn't decide priority, why is the person expected to basically get rid of all their stuff and move into a hotel room? So, so priority need is not dealt with under like prevention duty or at that stage, really. It doesn't really kind of come into play until later down the line. Now, in terms of why is the person expected to basically, so they're not, so legally speaking, there is a duty to protect property if the person can't look after it for themselves. And again, going back to that LGO, let me bring up an LGO case that kind of just illustrates this, because protection of property is quite a common thing, which again, I'll kind of pick one at random. So this one here, Wandsworth, I'll put the code into the chat. If you just check out this one in the LGO site, again, you'll kind of get an idea of how it all kind of works. So yeah, check that out. But yeah, the answer is you shouldn't be expected to get rid of all your stuff. But obviously, a lot of councils. I mean, I've seen councils basically say, yeah, we don't do that here. We don't protect people's property here. Now that's obviously, that's not going to fly with the LGO. But yeah, I think that's something which is probably quite common. If you look at Chapter 20 of the Code of Guidance, you'll get more information about how that kind of works and what the criteria is. So yeah, cool. Will, are we around for you on Monday? In fact, I'm not around. I'm travelling back from Somerset on Monday, so I'm not around. But I don't know if you are, for others and the rest. Hold on, Will's getting there. You're still on mute, Will.
Sorry, I was trying to get the mouse onto the unmute thing. Yes, I'm hopefully around on Monday. I'm really going to try, because I've missed a few Mondays, and I'll try and get something on for there. So yeah, let's provisionally aim for that. I'm sorry if I have to let you all down again at the end.
That's cool. Okay. Yeah, cool. And if not, see you next week, guys, on this channel Thursday evening. Hope this has been